Okay, there was a question after my previous video on Rajnesh versus Neha judgment as to what would happen if applicant wife does not file the affidavit of income and assets and liabilities along with her maintenance application. So the point is a very valid one, and let's have a look at what the judgment itself says. So I have opened the relevant paras of the Rajnesh versus Neha judgment. And I think this part is something we went over last time in the previous video. So in this video, I will focus on, uh, trying to find out as to what is the applicability or mandatory, requirement of filing a income and asset affidavit along with maintenance application. So if you look at para A, it says the affidavit of, disclosure of assets and liabilities shall be filed by the parties in all maintenance proceedings. So, and it includes even the pending proceedings. So basically, it is very clear that it has to be filed in all maintenance applications. It is not something which is a kind of optional for the applicant. So usually the applicant is wife. So that's the situation that the applicant has to file a income and assets affidavit. Now, para B again states the same thing. The maintenance application accompanied with the affidavit of disclosure of assets. So again, the application is not complete unless it is accompanied with the affidavit. So these paras we have already seen. These are more relevant for husband. So and it's covered in the last video. So I will not go over that. Let's me take you to the highlighted portions which are important for this discussion. It says that on the failure to file the affidavit, so usually it will be the okay. So I think this is refers to the husband if he fails to file affidavit after the wife has filed, then the court may decide the maintenance application on the basis of affidavit filed by the applicant wife and the pleadings on record. So it is very clear. I think there is no doubt. Again, what it says is that to decide the application of maintenance, there has to be an affidavit by the applicant wife. So it is not possible that there is no affidavit filed by her. Now, I think para D, just for the sake of completeness, the format of affidavit may be modified by the concerned court, but it does not say that the affidavit can be dispensed away with. It is mandatory. Then para E, it says that if apart from the information in the affidavit of disclosure, any further information is required, the court may pass certain orders. So again, it is like extra thing. It is doesn't say that that the affidavit of disclosure is in any way optional. So I think these are paras which are not relevant for this discussion. Let me go down. So I think that was about it. And why this is important is because one person replied on Twitter that his maintenance case filed by the wife is pending for more than a year, and she has filed a maintenance application, but she has not filed any affidavit, and that's the reason he also has not filed. So what should the husband do? In these scenarios, like will the case remain forever in that status? For how many years? So I think the CPC is kind of will apply the Civil Procedure Code, and the husband can file an application or a memo, or verbally state in the court that there has been a lot of delay and there is no affidavit on the record. So kindly the case may proceed and on the next stage, which will be evidence and then cross-examination and all those things. And usually people who file false cases, they are most hesitant to come for cross-examination. So in case they are not coming, then at least you are kind of free. You do not have the worry of that a maintenance application order has been applied on you. However, the only caveat is that as per Rajnesh versus Neha judgment, the order will be made from the date of application. So even at a subsequent date, if the applicant wife files her affidavit, then the interim maintenance may get ordered and it will be from the date of application. So the point what I'm trying to say is there is a legal situation, there is no point to hide away from it. In case there is too much delay in filing of affidavit by the applicant wife, husband can always go ahead and tell the court that he is ready for the trial, and let the applicant. It is the duty of the petitioner, the applicant, to go ahead and pursue their case, because that is the law actually. If you file a case, then you have to pursue it. You cannot just absent yourself from the court for indeterminate amounts of time for no good reasons. So that is what the husband has to bring to the attention of the court, and hopefully the case will proceed, and the things will be as per the on merits. So why this is also important is because what we are seeing is that women who are working, generally they are hesitant to file their affidavits, and sometimes even women who are not earning, not working, even they are hesitant because the affidavit has disclosure of your ITRs for last 3 years and bank statements for last 3 years. So many people will be hesitant because they may want to hide some information. So in a way, that's anyway good for the person on the opposite side, usually the husband, that you don't have to worry. In case the affidavit has not been filed, the maintenance order will not be passed. So that was what I wanted to discuss in this video. Hopefully it was useful. Thanks for watching.